All right, good morning, folks. So today we're going to talk about the right to privacy and with a focus on the Fourth and Ninth Amendment. Once again, I want to make sure that you receive all the relevant information. So I have my notes spread out in front of me here, and I'll be looking down. Sometimes I'll be looking into the camera. Hope you forgive me for that. So the first thing you have to understand is that privacy is a constructed right. Nowhere in the Constitution will you find a dedicated right to privacy. As you've read in the textbook and probably from other sources, you know that it is a right that's constructed from your First, your Third, your Fourth, and the Ninth Amendments. Okay? We have already talked about the First Amendment, but just to kind of clarify there, really, 5 rights. In the First Amendment, you got speech, religion, press, assembly, and petition. And it's the religion one where we kind of, there's an assumption of privacy that my religion, my right to practice my religion, should be a private matter, shouldn't involve government. Okay? Now, you can also see this again in the Third. Just kind of click that out there in the Third Amendment. So the text of the Third Amendment is almost irrelevant in today's world. No soldier shall, in a time of peace, be quartered in any house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. Now, we have no issue with the quartering of soldiers anymore. It doesn't happen. However, for our purposes, for the construction of a privacy right, we can see that there was this assumption. There's an allusion to that the house might be a private location that government can't enter. Okay, so we get a piece of that from the Third Amendment. All right. However, there's the strongest suggestion of privacy comes from the Fourth Amendment. So most of today's lecture will deal with the Fourth Amendment. All right. Now, when you talk about the Fourth Amendment, you're really talking about balancing liberty and freedom with security. How secure do we want our country to be? The more secure it is, the less freedoms we will have and the less Fourth Amendment rights we have. Okay? Well, let's look at the Fourth Amendment in particular. If you watched Hip Hughes and you know your finger game, I just kind of missed one for you. Third Amendment, First Amendment we just did for you. Third Amendment, a quick one to remember it, is you just do for me, it's the Boy Scout salute. So you go like this, boom, and that you can remember, oh yeah, no quartering of soldiers in my house. The Fourth Amendment, 4 fingers, curl your fingers, find some wood. Who's at the door? It's the police. Can they come in and search? Only if they have a warrant based on probable cause. So the text of the Fourth Amendment, let's read through that. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, the language there, the Fourth Amendment, demands a loose interpretation. You have to modernize that language, continually modernizing it and updating it to a modern world. So let's look at the specific questions here and see how it has to be modernized. So first off, what does the Fourth Amendment protect? It protects your person, your house, your papers, and effects. So regarding your person, does that mean your clothes? Does it mean your wallet in your back pocket? But in a modern world, does it mean your blood, your bodily fluid, or your breath if you're stopped by the police and asked to give a breathalyzer? Regarding houses, okay, so you got a house in 1789, no problem. But what about an apartment? What about the front porch of your house? What about a mobile home? Does it protect that as well? Regarding your papers, no, we don't write everything on paper anymore. So yeah, a diary, sure. A book in your house, sure. But what about email? What about your text messages? What about photographs? Okay, is that covered by the Constitution? Regarding effects, your backpack, yeah, possibly. Your iPad, I don't know. Your phone, okay? Those again are interpretations that demand a loose interpretation of the Constitution if you wanted to modernize it. Okay? All right. Other questions that we have to ask pertaining to the Fourth Amendment. Who does the Fourth Amendment protect? The language of the Fourth Amendment says the right to the people. Okay? And so who are the people? Is it just the citizens of the United States? Is it children under 18? What about undocumented immigrants? Well, what we learned, if you're a constitutional scholar, is that if we wanted the right to be limited to citizens, we said so in the Constitution. When we said the people, we meant all people living under the protection of the Constitution. So yes, even those of you that are under 18, you do have Fourth Amendment protections. Are they the same as people that are 18 and over? No, there is always that argument that, because we don't require the same obligations of you, we don't extend the same level of protections to you. So we will see that court case that kind of established that lesser standard of protection later on in this lecture. What about undocumented immigrants? Yes, they're protected by the Fourth Amendment. Okay, the people, it protects the people, not just citizens of the United States. Okay. What does the Fourth Amendment protect those people from? So this is the key piece. This is the majority of it, right? This is kind of the heart of the Fourth Amendment. It protects you from unreasonable searches and seizures. So the founders recognized that there'd be times that would justify a reasonable search or a reasonable seizure. Okay. So they look to balance liberty and order with security. Okay. They just note that a search occurs anytime government interferes with an individual's reasonable expectation of privacy. That's going to be a key piece there, just down the road, having a reasonable expectation of privacy. Okay, we might want to clarify seizure, though. What does it mean to be seized? I know what it sounds like to be searched, but seized, what does that mean? So I have been seized by the police whenever they stop me and they detain me, and I can't voluntarily leave. So they say, hey, Mr. Doctor, can we ask you a few questions? I'm like, yeah, sure. They ask me a few questions. Like, okay, I got to go. They say, not just yet. Okay, if they say not just yet, you have to stay. We got a few more questions to ask you. Then I have been seized. In the context of property, it is a seizure if I can't get my stuff back. Okay, they take it, and I'm like, I want it back, and they say no, then it's been seized. All right. So justified intrusions by government. This is where we get the piece about a warrant, is that we consider the intrusion justified. We consider the search to be reasonable if there's a warrant, which is just a legal document. And the legal document has been approved by a judge. Okay, so that's when they talk about it being, affirmed by a justice there. Okay, so the warrant itself is the legal piece of paper, but if a judge isn't going to validate that warrant if there isn't probable cause. So what is probable cause? Probable cause is, basically circumstances that would convince a reasonable person that a crime has happened or is in the process of happening. Okay, so it's evidence that would convince a person that a crime has occurred and that there's a fair probability that this particular person that I want to search is somehow involved in that crime. There's got to be evidence and there has to be a crime. Convince people that a crime has actually occurred. That's probable cause. It's way up for debate as to what exactly are the circumstances that are going to justify probable cause or give you probable cause. Okay. All right. Moving forward. So the expectation of privacy that was mentioned earlier. Here's the key piece. When we talk about justifiable intrusions, reasonable searches, it's always reasonable for government to come and search you if you do not have a legitimate expectation of privacy. So you think of all those locations where you have no expectation of privacy. Government can come and watch you there. Okay? So there is an expectation of privacy test. Because if I want to claim a privacy right, if I want to claim that the search was unreasonable, I have to have an expectation of privacy. So it's a two-pronged test. The first part just is, did you actually expect some degree of privacy? Not might, not often, or sometimes, just in that location, yes, I expect it to be private. Now, there are crazy people out there. So that's the second prong of the test. It's kind of the crazy people factor. So we take your expectation of privacy and we run it past the societal standard. It said, would normal people out there living in society agree with you that, yes, in that location, there is a legitimate expectation of privacy? Okay. If we determine that there is an expectation of privacy, then the general rule is that government's going to need a warrant based on probable cause to search. Okay? Bam. That's the general rule. Remember, 4 fingers, boom, 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 curl them up. Who's at the door? It's the police. Can they come in? No, not unless they have a warrant based on probable cause. Valid warrant. All right. However, there are times where the police do not need a warrant, and we call these warrantless searches. Okay? They still have to have probable cause, but the Supreme Court has determined that the extra step of having to get a warrant, signed by a judge, would be too burdensome to the police. Okay, so what are the conditions when all they need is probable cause and don't need a warrant? So the first one is with the person's consent. So anybody planning on living in a dorm room with roommates in college, you better understand this, that if the person consents to the search, then they can search. So the police show up at your apartment and your roommate says, if they say, hey, can we come in and search? And the roommate says, yes, then the police can come in and search. Okay, so with the consent of the person, then the search is reasonable. Okay, it is also, you do not need a warrant when it's necessary to protect the officer's safety. So a lot of times if they're transporting people or putting people in the back of the police car, there's going to conduct a quick search just to make sure that the officer's safety is going to be secure. When you have been seized based on valid grounds, then they can search you as well. So a lot of times that involves a traffic stop. They've already pulled you over because of evidence that you have violated, you've committed a traffic violation. In that case, they can search you and they can search your car. The other one that you want to be aware of is when the evidence is plain view. So your roommate lets them come into the apartment, they agree to the search, and then they're just walking around the apartment and they see all sorts of illegal stuff just lying about. Okay? When the evidence, that would give them probable cause to continue the search into other areas as well. When the evidence is in plain view. More likely what that means is that a police officer's on foot patrol, they're walking past a car, and they look through the window and they see lying on the seat of the car a big baggie full of marijuana. Okay, then they could enter the car and continue the search without a warrant. Finally, there are these things we call exigent circumstances. So if the evidence is about to be destroyed, and this is why cars are kind of, just a different animal, because cars are mobile, they can be moved. And so the evidence can be moved, relocated, and destroyed. So a lot of times you don't need a warrant to search a car because of the mobility of the evidence. The other one is when the police are in hot pursuit. They're actually on a foot race. They're chasing a criminal or a suspected criminal, and they see the criminal enter an apartment. They don't have to stop and get a warrant to follow the person they're chasing into that apartment. So hot pursuit. Just note there are circumstances when all the police need is probable cause. They don't have to go through the extra step to get the warrant. What's really crazy is that there are circumstances when the police don't even need probable cause. There's a lesser standard that's called reasonable suspicion. And this is the standard for traffic stops. And you can think of the traffic stops as kind of like random traffic stops. So there's a checkpoint and they're searching every third car. Okay. And it's a suspicionless search. It's also the standard that we use in schools for searches, reasonable suspicion. Okay. So reasonable suspicion is not the same as probable cause. It's a lesser standard. It's easy to achieve. And you'll note the big difference is the word could here. So reasonable suspicion means that a person might reasonably believe. There are circumstances, there's evidence to suggest that a crime might have happened or might be in the process of happening. And you know what? Maybe this person's involved in it. Can't be a hunch. You have to have some evidence to suggest that there's a possibility that this person's involved in this crime or this thing that might be a crime. Okay, so it's a lesser standard. So, and to maybe help explain this, when you're talking about a suspicionless search, so if there's a random checkpoint and the cops are stopping every third car and giving people breathalyzers and looking for drunk drivers. And you're like, wait, there's no probable cause there to suspect that me, the individual driver of that car, is driving drunk. I haven't been weaving down the street, right? Nothing like that. They're just randomly checking people. So, however, if everybody is leaving a concert where alcohol has been served, where then maybe the cops know that there's been illegal drugs taken as well, then there is reasonable suspicion to believe that some people leaving that concert might have chosen also to drive. Okay, so in that case, the random suspicionless search is probably reasonable and allowable under the Fourth Amendment. Okay, so some key factors to determine reasonableness. So if you ever get to a case study, not saying there will be one, where you have to determine reasonableness, there are three things to look at. Okay, so the first one is how dangerous is the item that you're looking for. Okay, and then is how reliable is the information, and thirdly is how badly is the person's privacy being invaded. So if I'm a school administrator, because we'll talk about this as being the standard for schools in a minute here, and I'm looking for, prescription strength ibuprofen. You're not supposed to have it, and you're only supposed to have it if you have a prescription from a doctor, right? Okay, it's not that dangerous. It's ibuprofen. Okay, so what's the scope of my search that I'm going to go to find that particular illegal item? Am I going to search your backpack? Probably. Am I going to search your person? How am I going to search your person? Is it just going to be a pat down, or is this going to involve the removal of clothing? If the item's more dangerous, like I'm concerned about your personal use of drugs, like illegal drugs, I might, extend the scope of my search. If I'm more concerned about you distributing drugs at school, then my level of concern rises and I might increase my scope again. Okay, but at what point is it going to be justifiable in a school setting for someone to conduct a search that involves the removal of clothes? That is a tricky case. If you want to know a case about that, just look up Savannah Redding case. It was all about that. Okay, again, how reliable is the information? Now, in the school setting, you think about the most dangerous item, of course, is going to be a weapon. And then I'm going to be extending my scope. I'm going to want to find that if my information is really reliable, that there is one. Okay? And I will go to great lengths and invade someone's privacy to great lengths to find that particular item. So 3 things for reasonableness. How dangerous is the item? How reliable is my information? And to what extent am I going to invade someone's privacy? All right. So some court cases that you need to know, not for the AP test, but for other content. So like the Mapp versus Ohio test, I just don't understand why it's not one of the required cases. It's a huge case. Now, we always connect Mapp v. Ohio with the exclusionary rule. The exclusionary rule itself existed prior to Mapp. It was first constructed in a case of Weeks versus the United States. But the thing is it only applied to the national government. So Mapp versus Ohio is a case of incorporation. It incorporated this particular rule as a protection against state government intrusions as well. So the facts of Mapp. So here's the case. You had Dalree Mapp. She was dating a gangster, a mobster in Cleveland, Ohio. Okay? And the police received an anonymous tip that this mobster was hiding out in her house. So they went to the door, they knocked on the door, yes, and then they're like, well, Miss Mapp, we believe there's a gangster that's involved in a bombing from 3 days ago, hiding out in your house. We'd like to come in and search. And she said, do you have a warrant? They said, no. She said, well, go away. So they went away across the street where they proceeded to stake out her house. Okay, nothing happened. So 13 hours of this staking out, they'd had enough. And they went back to the door. Okay, and they knocked on the door again. Nobody answered. So they kicked in the door and entered the house. And there's Dalree. She's sitting there. She's like, wait, you can't come in here. Do you have a warrant? And they said, yeah, sure, we got a warrant. And they hold up a little tiny piece of paper, okay? And she grabs that piece of paper and she stuffs it inside her shirt. And then a wrestling match ensues. And the police get back the warrant, and that's the last the warrant is ever heard from, okay? All right, so they proceed to search the house. Boom, 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 floor to floor. They find nothing. But in the basement, there's this Foot Locker. And remember, they're searching for a person. Can a person hide out in a Foot Locker? A warrant is supposed to tell you exactly what you're searching for and where you can search. Okay? So here's the deal. In the Foot Locker, they find, it's like this. You got this police officer that opens up the Foot Locker. They go, oh, hey, Billy, you better come over here. I think we found some stuff here. I think we found ourselves a nice Foot Locker full of illegal pornography. Billy comes over, starts flipping through it. Yeah, and we got ourselves some illegal pornography there. And they arrest Dalry, okay? And they go to court. And she's sentenced to 1 year in prison for being in possession of illegal pornography. Now, during that court case, they never submitted the supposed warrant that they had, okay, to justify the intrusion. Okay, to say that they had a reasonable, they had probable cause and a valid warrant to search your house. So she sued and it went all the way to the Supreme Court. And the Supreme Court said, well, the exclusionary rule already exists. And the exclusionary rule says is that any evidence that's found via an illegal search cannot be used in court to gain a conviction. So they incorporated that to the states and said, yes, states also have to follow the exclusionary rule. And they sent it back to retrial. Okay. So they remanded the case back to the states to give Dalry another trial, not using the evidence that they had found illegally. Okay, because you can only use evidence you found via a valid warrant. All right. So exclusionary rule, it's huge because most of our interactions with the police, most of the times we get searched is going to be with the state police. We rarely get searched by the FBI, okay, by the national police. So this was huge, Mapp v. Ohio. Huge protections for us. All right, moving on. Okay, New Jersey versus TLO. This is the case that I've been kind of alluding to the whole time here. TLO was a high school student. School officials got tips or were concerned that she was smoking cigarettes in school. So they searched her purse. And yes, they found cigarettes, but when they dumped out the purse, they also found small amounts of marijuana and a notebook like this, filled with names and dollar amounts next to it. Very clear that TLO was involved in the distribution of marijuana at school. It was like, selling it. All right. So they actually turned that evidence over to the local police, and she was prosecuted and sent to probation. Okay. But TLO, which is like kind of her initials, by the way, she sued and went all the way to the Supreme Court. So the question before the court, there were two questions. Is one, does the exclusionary rule apply to searches conducted by school officials? But first, they had to determine, did the assistant principal's search of her purse violate the Fourth Amendment? Because they didn't have probable cause, they didn't have a warrant to conduct a search of the purse. Okay. Now the school, the ruling is that the school itself doesn't need probable cause, doesn't need warrant. They just need that lesser standard of reasonable suspicion, which is very easy to achieve. So they had reasonable suspicion that TLO was smoking at school, smoking cigarettes. And so when they searched for that was a legal search. So any evidence that they find via a legal search can then be used. So the marijuana evidence could be used even though it wasn't what they were originally looking for because they had conducted a legal search. So schools, lesser standard. Very easy to conduct searches in schools. All right. Moving on, though. So far, we've talked about the First Amendment with your freedom of religion as being part of a construction of your privacy right. Your Third Amendment, right? Boom, that your no quartering of soldiers suggests some kind of privacy in your house. Fourth Amendment, much stronger allusion to privacy. Boom. Who's at the door? The police. They can't come in unless they have a valid warrant based on probable cause. The Ninth Amendment is kind of the last piece where we see the construction of a privacy right. So again, a finger game to remember the Ninth Amendment and what it actually says. You'll note that you see 9 fingers, right? You can only see 9, but you know that I have 10 fingers, right? So you apply the same concept to the Bill of Rights. I have more fingers than you can actually see. And the Ninth Amendment says that you have more rights than are actually listed in the Constitution. So there are more rights out there, which begs the question, what are these rights? And that is like a huge piece of having a privacy right, is that there are more rights that aren't listed in the Constitution. So we get to Griswold versus Connecticut, 1965. And this is where we see the court construct a privacy right. Actually, in their opinion, say, yes, there is a right to privacy. So the facts of the case, give me 1 second here. Okay, Estelle Griswold was the head of Planned Parenthood in Connecticut. And Connecticut had a law that prohibited contraception. Okay? And she was in the business of counseling adult couples, marital couples, on how to avoid pregnancy. So she was arrested and charged with violation of this law. And it went all the way to the Supreme Court. And the question before the court was, does the Constitution protect marital privacy when it comes to decisions involving contraception? Okay. And again, so the court said, yes, there is a privacy right, that the First, the Third, the Fourth, and the Ninth Amendments create a penumbra or a shadow, and in that shadow exists your right to privacy. Kind of like it. It's the shadowy right. Okay. And at this time, that right, though, was going to be limited to marital couples, and it really only involved the topic of contraception. Contraception itself was, whether or not to use birth control. That was a private conversation for married couples, and government shouldn't interfere with that. But it's just a hop, skip, and jump from that, from contraception, to the next topic that we still see huge ramifications with today. So though Griswold versus Connecticut is not your AP required case, it set the stage for your AP required case. Without Griswold, the next case never would have happened. So our final case, and this is kind of where I'll sum it up today, is Roe v. Wade, 1963. So it's just down the road from Griswold v. Connecticut. And the facts of this case is Jane Roe is a fictional name. Okay, and she claimed that the Texas law that prevented abortions violated her right to privacy. So it was kind of a planned case. There was a couple of there was a lot of states. There were some states that had kind of liberalized their abortion laws, and there were some states where it was not. It just, boom, couldn't happen, right? And they planned to have some lawsuits in these cases and then appeal them to the Supreme Court. So the question was before the court is, does the Constitution recognize the termination of pregnancy as a private matter that's guaranteed by a right to privacy? All right. And the holding is intriguing because they said yes and no. What the court did is they exercised one of those balancing tests. They said, yes, a woman's right to choose falls within one's privacy right. Like abortion itself, the termination of pregnancy is a private matter and government should not be involved in it. However, it's balanced against a compelling government interest. And in this case, there was two compelling government interests. They said, one, the woman's health. Ensuring the woman's health is a compelling interest for the government, and the potential life of the fetus is a compelling interest for the government as well. So in the first trimester, the court found that the woman's privacy right outweighs the state's compelling interest. And a state would have a hard time denying the right to terminate a pregnancy in the first trimester. In the second trimester, they said they're more balanced. And a state can put reasonable limitations on that privacy right in the second trimester. When you get to the third trimester, the state's compelling interest outweighs the woman's privacy right. So there's very few circumstances that would allow for the termination of a pregnancy by the time you get to the third trimester, because the state's compelling interest outweighs the woman's privacy right. Fascinating decision by the court there. It's led to a lot of strife in our society, though. Okay? All right. Well, that's it for today, but let's review kind of the main pieces here. One, a privacy right. It's a constructed right. It's constructed from Amendment 1, especially the pointing up there, freedom of religion. Amendment 3, no quartering of soldiers. Amendment 4, your protection from unreasonable searches and seizures, and Amendment 9. Okay? The one that says there's more rights than you can actually see are listed in the Constitution. And then via the 14th Amendment, the Due Process Clause of the 14th Amendment, it would be incorporated to the states. It'd be a protection from state government intrusion as well. All right, the general rule of the Fourth Amendment, remember that in general, if the police want to come and search your house, they need to have a warrant, a valid warrant based on probable cause. However, there are conditions that allow for warrantless searches, and there are conditions yet that allow for suspicionless searches. Okay? School officials only need to have that lesser standard of reasonable suspicion. Okay, we got that from New Jersey versus TLO. And the exclusionary rule says that evidence collected while exercising an illegal search cannot be used in court to gain a conviction. Okay, originally that was Weeks versus United States, but then it was incorporated to the states in Mapp v. Ohio. Okay. Finally, the right to privacy was constructed by the court in Griswold versus Connecticut, okay, but it was limited to married couples and the topic of contraception. But in Roe versus Wade, 1973, your privacy right was expanded to include abortions and discussions around determinations of pregnancy. That is a private matter, at least in the first trimester. All right, thanks for coming, folks. Don't get in trouble. I'll talk to you again possibly on Friday. All right.